I think that the State Department will be able, over time, to release all of the records that were provided.
Madam Secretary, two quick follow-ups. You mentioned the server. That's one of the distinctions here. This wasn't Gmail or Yahoo or something. This was a server that you owned. Is that appropriate? Was there any precedent for it? Did you clear it with any State Department security officials? And did they have full access to it when you were Secretary? And then separately, will any of this have any bearing or effect on your timing or decision about whether or not you run for president? Thank you.
Well, the system we used was set up for President Clinton's office, and it had numerous safeguards. It was on property guarded by the Secret Service, and there were no security breaches. So I think that the use of that server, which started with my husband, certainly proved to be effective and secure. Now, with respect to
Clinton, and 62 votes for Senator Sanders.
All right.
Oklahoma, you have 42 votes. How do you cast your vote?
The great state of Oklahoma is proud to be here at the Democratic Convention. I'm proud to recognize this.
If I could ask everybody to settle down. Thank you so much. Everybody settle down, please. All right, we have a big program. We have a big program today. Let's hear. Let's be respectful.
I've known Hillary for almost a quarter century. I've never met anyone smarter, tougher, or more ready to lead us forward.
Boy, we have 63 days to go.
Not approving. If you need to read a note from your lawyer, you're welcome to, Madam Secretary.
No, it's just hard to sit here listening to the comments you're making about someone that I consider to be a great American. If he said he made a mistake, that's even more proof of what a fine gentleman he is and what a great public servant he's been. It doesn't in any way, what you're saying, impugn his service for 40 years, and certainly not his service on the Accountability Review Board. I can't help it, Mr. Chairman, that you all don't like the findings of the Accountability Review
Ma'am,
Board.
we had
I can't
two
help
hearings.
it that you don't like the
We
findings
had
of all
two
the other
hearings.
congressional committees.
We had two hearings where we did nothing but discuss the implementation of the ARB findings, Madam Secretary. So with all due respect, we've had more hearings about the ARB findings than we have with you. So don't tell me that we don't care about the ARB. We had two hearings. My point is this: the ARB nor the previous congressional investigations had access to your emails, did they?
I don't know what they had access to. I know that during the time I was at the State Department, there was certainly a great effort to respond to your predecessor, Congressman Iss's inquiries, and many thousands of pages of information.
Thank you. It's my understanding, Mr. Higgins, Mr. Samuel, and Mr. Soul, that Ms. Walsh's statements reflect the IC. Okay. We'll now recognize myself for the first set of questions. Mr. Herring, what information do you believe that Congress does not have the right to see?
So we believe it's important for oversight committees to understand how the FBI reached our conclusion.
No, wait. I'm asking you a philosophical question here. What does Congress not have the right to see?
So I don't know if I can answer that in a way that, I think there's more to it than a simple answer. I think that each case is sort of specific to its own set of facts. I think Director Comey tried to be as transparent as he could with this committee.
Do you think he could be
other committees as he responsibly can be? So I think when he spoke and he answered questions.
What is it that I, as a member of Congress, or any member on this Congress, either side of the aisle, what is it that you believe we don't have the right to see? See, this is the way our government works. We get to do oversight. That's why since 1814 this committee has been doing that. There's executive privilege. Let me help you. There's executive privilege. Has the President invoked executive privilege in this case?
No.
The answer is no. Good. That's right. The answer is no. Is there any other situation?
Look, when it comes to classified information and the classification that deals in the executive order, not all the information that we have in our files belongs to us. We defer to other agencies when it comes to access to their classified information.
But you are the ones that put redactions on personal identifiable information, correct?
We did on the personal identifiable information, that's correct.
Where in the Constitution does it say that I can't see that?
Does it address it specifically in the Constitution?
So, can you cite any legal case, any precedent that says that Congress can't look at personal identifiable information?
I cannot cite any legal case.
Are you aware that Congress is exempt from the Privacy Act?
I am.
Does the FBI treat congressional document requests as FOIA requests?
No.
Will the FBI provide Congress all of the 302s?
All of the 302s, we have one set that you've been provided already. The rest of them are coming through the FOIA process.
Wait.
Yep.
We're not, FOIA process? You mean I got to fill out a FOIA request?
You can. Not necessary.
Here's the problem. You handpicked the 302s to give to us. My understanding of discussion with staff, and I appreciate your accessibility with the staff. You've been good, and you're new, and for your first time hearing, this is a tough one, but the reality is you should give us all the 302s.
So let me say this. I think the director made principled decisions about what to say to Congress when he was here and also what to provide to Congress. As far as
Wait, where do I find that? Do we just let everybody in government decide that they're based on their own individual principles? That's what see, it's trust but verify is how it works. You don't get to decide what I get to see. I get to see it all. I was elected by some 800,000 people to come to Congress and see classified information. I was elected by my colleagues here to be the chairman of this committee. That's the way our Constitution works. Will the FBI provide to Congress the full file with no redactions of personal identifiable information?
I cannot make that commitment sitting here today.
Then I'm going to issue a subpoena, and I'm going to do it right now. So let's go. I've signed this subpoena. We want all the 302s, and we would like the full file. You can accept service on behalf of the FBI?
Certainly.
You are hereby served. We have a duty and a responsibility. You can cite no precedent, nothing in the Constitution, no legal precedent. You know this is important to us. You now have your subpoena. We would all like to see this information. I've gone past my time, or coming up on going past my time. I'll now recognize the ranking member, Mr. Cummings.
You've been in the job 4 weeks. I can't hear you.
Yes, sir.
And you used to work for one of our distinguished colleagues, Mr. Goodlatte, is that right?
Yes, sir.
Republican. So I'm going to, so you're familiar with Congress then?
Yes, sir.
I'm going to save most of my questions for the classified session, but I do want to address the redaction issue briefly. When the FBI produced these materials to Congress, their cover letter stated, and I quote, "The FBI has redacted personally identifiable information as appropriate," end of quote. Chairman Chaffetz publicly announced he wanted the FBI to lift these redactions. He stated, and I quote, "We are going to call on the FBI this week, to give a version where there is non-classified, the unclassified material and the classified material redacted so that could be out there in the public," end of quote. The problem is that there is no legitimate basis for the demand. Director Comey has already provided us with an unprecedented level of transparency into the FBI's investigation and internal decision-making. Now, I want to stop there for a moment. And you said yourself, I think at least twice, that there has been unprecedented discovery here. I mean, what did you mean by that? I don't want to take the words out of your mouth.
No,
correct me if I'm wrong.
I think in this particular case, we don't typically make our case files available. They're sort of internal work product. There's a lot of sensitive information in there. Even the unclassified stuff is sensitive to a great deal. I think that we made a principled decision with redacting the PII only for those individuals who are not already in the public domain. And you sort of ask, why did you do that? Well, from my perspective as an agent.
Committee on Oversight and Government Reform will come to order, and without objection, the chair is authorized to declare a recess at any time. A very important hearing today. As you know, the committee has jurisdiction. They have jurisdiction on federal records. They have jurisdiction on the Freedom of Information Act. They have jurisdiction on the National Archives. It's a very important part of our process. We're unique in our nation. We are open. We are transparent. We do provide access to the American people for what they paid for. As you also know, Secretary Clinton served as the Secretary of State from early 2009 through early 2013. But here's the problem. Since 2009, there have been thousands of congressional inquiries, thousands of FOIA requests, subpoenas, media inquiries. And if any of those required Secretary Clinton's federal records, i.e. her emails, there was not a way for those requests to be fulfilled. This has created a mess and a disaster for the people on the front line who have to deal with this. And we're thankful for the 4 people that serve the United States. They serve in the State Department. We appreciate them being on this panel and having to deal with this mess that Hillary Clinton conveniently created for the State Department on her way out the door. Remember, when she left in early of 2013, it wasn't until December 5th of 2014, closing in on 2 years later, candid and honest with the American people. You allow Congress to do its job. I didn't pick this timeline. Hillary Clinton picked this timeline. I don't care about the election, what time it is. We're going to keep going at this full speed ahead. It is far, far too important. With that, I will now recognize the ranking member, Mr. Cummings, for 5 minutes.
Thank you very much, Mr. Chairman. To the witnesses, I hope that as you listen to the chairman, if you think that the cases that he has cited, previous cases involving, for example, the U.S. attorneys are distinguishable from what's happening here today, I'd just like to know. I think he makes a very good point, other than the fact that I guess in some of those cases at least, the Justice Department was accused of doing something wrong. But I'd like to know exactly where you all stand on that, because I think he makes a very good point. Well, here we are again, another day in the Oversight Committee, another emergency hearing about Hillary Clinton. Today is the second hearing about Secretary Clinton we have held in 3 business days. And tomorrow we will have a third. For the record, Mr. Chairman, I want to thank you, and I want the American public to know that you have agreed to schedule a hearing on EpiPen, which affects so many of our constituents, because that too is an emergency situation for the constituents of every member who sits here in this chamber right now. As far as I can tell, the only emergency is that the election is less than 2 months away. The real reason for today's hearing is that FBI Director James Comey refused to be summoned before this committee yet again. He refused. Director Comey has already bent over backwards, departed from long-standing law enforcement precedent, and provided our committee with an unmatched level of transparency about his internal decision-making regarding this investigation.
By releasing the investigative summary and the 302s.
Thank you very much.
Thank you.
Some of the 302s. And when you don't show up at a meeting that we request behind closed doors, kind of lose that opportunity.
If I could,
now we're going to recognize the gentleman from South Carolina, Mr. Gowdy.
Agent Herring, did the FBI interview the sender of all emails that contain classified information?
I don't know the answer to that question, only because I'm a Ledge Affairs guy. I was on the investigative team.
Can you find out? You would agree with me it'd be important. I mean, you'd want to interview the person who sent the classified information, right?
Certainly.
Because the recipient thought the C was just the third letter in the alphabet. You might be curious whether or not the sender also was clueless in the way he or she viewed classified information, would you not?
That would be a logical investigative step.
Can you find out whether or not you interviewed the sender of all emails that contain classified information?
Certainly.
Do you know if the sender of any of the classified emails knew that the information was classified at the time?
I don't personally know that. I wasn't part of the investigative team. I'm sure that.
Can you find out?
Certainly.
Can you find out for me?
Yes, sir.
There are folks wondering how information gets from a classified source into an email. Did your investigation shed any light on how classified information could get from a classified system into an unclassified email to even be sent? I'm not even talking about the receiving of it. I'm talking about the sending of it.
I'm sure they did look at that. That would be sort of a logical question you would ask as an investigator in a case like this.
That's what I thought.
But in my legislative sort of affairs capacity, I just don't have that kind of visibility.
Well, don't sell yourself short. You used to be an agent, right? Still an agent, right? So you know what you're doing. Did the FBI grant immunity to anyone during the course of its investigation?
For immunity questions, I'd have to defer to the Department of Justice for that. It wouldn't be an agent who would grant that kind of thing.
Did the Bureau recommend the granting of immunity?
I do not know.
Do you know whether the Department of Justice granted immunity to any witnesses?
I know I saw some articles last week, but that's the extent of it.
Well, surely you got better sources than the media for that, don't you? You can ask the guy sitting 2 people down from you.
I would have to defer to the Department of Justice, sir.
Do you know whether any witnesses asserted any privileges while they were being interviewed?
I don't know.
But the Bureau would know that, right? Because they would have asserted the privilege while you were in there.
I'm sorry?
The Bureau would know that, right? Because that privilege would have been asserted perhaps while you were in there conducting the interview.
What kind of privilege are you talking about, like attorney-client privilege?
Oh, there are a bunch of privileges. There's priest-penitent. I'm guessing that one didn't come up. There's doctor-patient. I'm guessing that one didn't come up. There's the Fifth Amendment privilege against incrimination. That one might have come up. Attorney-client privilege, again, there have been media reports that one came up.
Sir, I just don't know the answer to those questions.
Have you ever had the attorney-client privilege come up during any of your investigations?
Certainly.
Who does the privilege belong to?
The client.
So the client can waive it, right?
Can.
You understand why Congress might want to know whether or not the attorney-client privilege was waived and who the client was?
I can certainly imagine.
Yeah, me too. That's why we want to see the file, Agent. I mean, you say it's unprecedented. Mr. Cummings used to be a criminal defense attorney. He got to see all your 302s. Ken Buck used to be an assistant United States attorney. He got to see all your 302s. Probation officers get to see all your 302s. Why can't Congress?
Sir, I think we have tried to provide the information in a way that is understandable. I think the investigative summary tells kind of the story, and I do think that the 302s that we provided are the important ones.
Well, let me ask you this. If those summaries were all anyone ever needed, why don't you just introduce those in trial? Why actually call the witness?
Well, certainly we actually trying to make your life a little bit easier in the light of the
But see, I don't want my life being made easier. I don't want that. I want to know what was said in the 302s. Because the 302 is itself a summary of an interview, right? It's not a verbatim transcript.
That's correct.
So you have given me the summary of an interview. And I'm not asking for a verbatim transcript because you don't have one. Certainly. I'm just asking for the 302. So I don't have to read your summary. I may read the 302 differently from the way you read it. So why not?
So I think we've given you the relevant ones as
relevant according to whom? I am telling you, I don't think you've given me all the relevant 302s.
Well, the remainder of the 302s will come out through the FOIA process.
But since when did Congress have to go through FOIA
Correct.
to obtain 302s from an investigation that's not even resulting in any prosecutions that your boss has already said is over? Since when did we have to go through FOIA?
So I think that the 302s we have provided, I think that we made a principled decision about what to provide. It was certainly made at the highest levels of my agency.
All right, I'm out of time. That's what that knocking sounds. I'm just going to say with all due respect, you don't get to decide what we think is relevant. And I do say that respectfully. The defense attorneys get it all. I think Congress ought to get it all.
Thank the gentleman. Now recognize the gentleman member, Mr. Cummings, for his opening statement.
Thank you very much, Mr. Chairman. I want to make sure, Mr. Kennedy and witnesses, that as we address this mess and as we address this disaster, as the chairman has described it, and as we enter this hearing entitled Examining FOIA Compliance at the Department of State, that we make sure that we look at the entire problem. I want to know how far back it goes. And if we are about the integrity of this committee and truly addressing FOIA compliance, I hope we'll take a look and see what happened even before Hillary Clinton and what happened afterwards. Integrity of the committee. Integrity of what we are supposed to be about. Integrity of using the taxpayers' dollars wisely so that we might be effective and efficient in what we do. I wish I could say that I support today's hearing, but I think everyone in this room knows what is really going on here. This hearing is not about an effort to improve FOIA or federal record keeping. This is an attack on Hillary Clinton's candidacy for President of the United States of America. And just the latest in a series of attacks. The Republicans started with their discredited Benghazi investigation, accusing Secretary Clinton of all kinds of unsubstantiated conspiracies. When they turned up nothing, they just made up new accusations against her. Then, when the FBI director, Mr. Comey, sat in that very seat, in that witness chair, and debunked those allegations, the Republicans responded by attacking the FBI director and then making up more accusations against Secretary Clinton. When Mr. Comey came before us, I told him that unfortunately, while at one time he was the darling of the Republican Party, now he was being placed on trial. The chairman sent a perjury referral to the Justice Department that is ludicrous on its face. Then he sent another referral.
And converted another 25 positions from part-time to full-time. This comes at a time when the department's operation operational funding has increased 25% in constant dollar terms over the last 5 years. We're taking it out of Hyde. While we have had a dedicated FOIA requester service team to answer questions about specific status requests, a new FOIA public liaison officer joined the State Department in May to enhance our ability to be responsive to the American public. Have these steps made a difference? Yes, we are beginning to see results. In fiscal 2014, we achieved a 23% reduction in our appeals backlog by streamlining our case processing. In fiscal year 2015, the Department closed 9 of our 10 of its oldest FOIA requests. Later this year, we plan to start posting nearly all of the documents released through FOIA, no matter who the requester was, on our public website. This will result in more material on broader ranges of topics, potentially reducing the need for anyone to file a new request for information that has in fact already been reviewed. The Department is committed to finding more ways to streamline the FOIA process and to reduce our backlog. We look forward to exploring this issue with you today. Mr. Chairman, that concludes my statement. I have a written statement that I would ask to be included in the record.
Absolutely.
And I and my colleagues are open to your and the committee's questions. Thank you, sir.
Thank you. Now recognize myself. Let me address the Secretary Powell issue. Here's some important differences. First of all, the Inspector General, who we rely on heavily, was able to go back and speak with the former Secretaries of State, except Hillary Clinton, who refused to be engaged with the Inspector General. In Secretary Clinton's case, this is the only case that I'm aware of where there has been an accusation of a destruction of documents that were under subpoena. Mr. Comey, the FBI director, came and testified before this committee that they didn't look at any of the comments that Secretary Clinton gave under oath. And I would also point back to the January letter of this year where we asked the State Department to look back 15 years, not just picking on one, but 15 years, which is a long, I think, exceptionally long time, but looking back, and certainly emails have changed. And finally, I would just suggest that I think there are legitimate concerns about retroactive classifications, over-redactions, those types of things. And I'm pleased to report to the committee, because I think Mr. Cummings has some legitimate concerns, that we're going to get a chance to question those people on Monday. That's why we're doing the hearing. It is an embarrassment that the unclassified documents that are residing in the SCIF, unclassified, are only able to be reviewed by members of this committee, the Appropriations and Judicial Committee. If you reside in another committee and are a member of Congress, you are prohibited by this administration from looking at unclassified documents. I don't know how to explain that, and I think it's absolutely wrong. Mr. Finney, you are on the front lines. I know the management team at the State Department didn't want you to be here because we had to issue a subpoena to be here, and I don't take that as you in your personal capacity making that decision. But nevertheless, we're glad that you're here. You have been in this position since 2006. You didn't ask for this. I'm very sympathetic to the...
She came on board. You know, they asked the question, will she have a state.gov account? And I was told she would not. And also, that was something that was not uncommon because the secretary prior to her did not have a state.gov account. And also the secretary prior to that previous secretary did not have a state.gov account. So
the fact that you weren't getting any records from Hillary Clinton, did you ever raise that question, that concern? Were you told to, what did they tell you to say or not say about that?
No one told me anything to say or not say. Again, because she didn't have a state.gov account, that was something that was not abnormal because previous secretaries did not have state.gov accounts. The records that we were receiving were placed into our repository, which is the Secretary Tracking and Retrieval System.
But you got the Secretary Clinton dump of 55,000 pages almost 2 years after she left, correct?
You say that, not knowing the exact time frame, sir. I would just say that, yes, we did receive them.
Okay, I believe that was December 5th of 2014 when Mrs. Clinton, Secretary Clinton, returned 55,000 pages of emails. Has the State Department after December 5th, 2014, has the department received any additional Hillary Clinton work emails that were federal records?
After the 55,000, that's what you're saying specifically?
Yes.
Recently, my office was involved in some records that they had just recently received. But in that particular case, the only purpose that I was involved with was really just looking at the records, seeing if they were personal or work-related. And that was the reason why we got involved in that process, because the department was receiving so many records and the staffing was lacking.
So, Ms. Lang, how many records did the State Department receive after December 5th, 2014?
I'm sorry, can you be more specific? Are you talking about from Secretary Clinton, from other former employees?
No, I'm talking specifically about Hillary Clinton work emails that were federal records. How many did you get after December 5th?
The Federal Bureau of Investigation has transferred a number of documents to the State Department.
And what is that number? Do you know the number?
Those are still undergoing a records review.
Was it 17,448?
My office in the Executive Secretariat staff is not leading that effort.
So who is? Who knows this number? Ambassador Kennedy?
Mr. Chairman, we've received a number of disks from the FBI. We are in the process of inputting them into our classified analysis system and counting them. And we know of 14,900 odd documents, and the FBI has mentioned that there could be tens of thousands others in the string of disks that we're processing now.
And all of those came after December 5th, 2014?
All of those, Mr. Chairman, were received within the last month.
Ambassador Kennedy, on May 22nd, 2015, you asked, as the representative of the State Department, you asked Secretary Clinton's attorney, David Kendall, for an electronic copy of the 55,000 pages of emails. When did Secretary Clinton provide the electronic copy to you?
Intervening in that thing, Mr. Chairman, the FBI then took possession of all the electronic material that Mr. Kendall had, to the best of my knowledge.
So did Secretary Clinton fulfill your request to return the federal records via electronic format?
The Secretary Clinton's attorney, to the best of my knowledge, provided that electronic material to the FBI.
Or it was seized, one of the two. But I'm asking, it's kind of embarrassing that you had to ask them to return it in electronic format. They went and printed all this stuff out and gave you hard copy. So did they ever give you an electronic copy per your request?
To the best of my understanding, Mr. Chairman, they no longer have an electronic copy because it's in the possession of the FBI.
Because it was seized, right? Yeah. So, and you have since asked the FBI to turn over that?
We have asked the FBI to provide us with any material that they have in their possession that may be federal records. As I mentioned a moment ago, Mr. Chairman, they have provided us with a number of disks. We are loading that system, those disks, into our electronic system so then that we can, first of all, disaggregate the time periods, because there are potentially records there prior to when she was Secretary of State and after when she was Secretary of State. Secondly, because this is their recoveries from her servers, there could be material in there which are federal records and material which are not federal records. So we have to disaggregate those, and then we will process all the federal records as we would do for any federal record.
So what number are you up to now, do you know?
As I said, right now we're up to 14,900 documents that we are reviewing in both the two stages of disaggregation first.
Okay. Well, last question. I've exceeded my time, but how do I get Hillary Clinton's calendars? Why does that take so long? The original FOIA request came in 2010, and you're arguing in court that you still can't get it done by the end of the year. A judge has had to intervene to force you to produce calendars. How difficult is a calendar? Who's in charge of that, by the way?
Mr. Chairman, when we have 30, 1,000 FOIA requests pending. We also have requirements under statute to do what is called historical declassification, in which we have moved 26 million pages in the last 5 years.
Okay, wait. All I'm trying to talk about is Hillary Clinton's emails, or Hillary Clinton's calendars. I would like to see, as chairman of the Oversight Committee, I would like to see Hillary Clinton's calendars. When can you provide that to me?
I will find a time and get back. I will find when that is and get back to you.
When will you get back to me by? The end of by Tuesday?
By Tuesday, I can give you an idea when that information might be available. If I might, sir, the AP request.
Politics as usual, stirring up a hornet's nest over documents he can't see, which are being withheld by his own party. And it seems that they do not want to open up the Intelligence Committee's jurisdiction at this point. I don't know why they're not taking the vote that would allow him to see these documents. But what our committee is engaged in is nothing, in my opinion, nothing more than a partisan election bashing exercise, stating that these emails can't be seen when they can be seen if his own party votes to let him see it. So I just say that it's politics as usual, and I'm disturbed about it. There is a problem with the classification system. We all saw that in the last hearing. Let's work together to correct it. But this whole charade is just that, a charade. These documents are not being withheld from the chairman because of anything any of these witnesses have done. They are being withheld by the Republican chairman of the Intelligence Committee. So I respectfully suggest to my chairman that we bring in the chairman of the Intelligence Committee and ask him why he doesn't have a vote and release the documents to you. It is not the FBI, but the House Select Committee on Intelligence who's withholding these documents. So,
will the gentlewoman yield?
I most certainly will.
Any one of the 4 people from the intelligence community here can help answer this. Have you made redactions on personal identifiable information to the Intel Committee? Mr. Higgins, how about you?
No, we have not.
There's no redactions at the... Ms. Walsh?
Not to my knowledge.
Mr. Samuel?
No, Mr. Chairman, not to my knowledge.
Mr. Sewell?
No, Mr. Chairman, not to my knowledge.
Can you release these emails into the public? And if so, what would happen? Mr. Higgins, what happens if we release these emails on Hillary Clinton's unsecured server? What happens?
Mr. Chairman, I can confirm that CIA participated in a classification review process, and I'd be happy to talk about that process in closed session. Needless to say, some of the materials do include classified information that we do not believe is appropriate for public release.
And are some of these materials include sources and methods?
Mr. Chairman, I'd prefer to discuss any further matters relating to classification in closed session.
Gentlewoman's time has expired, but thank you so much for yielding to me.
But reclaiming my time, I get to close in my time. You took all my time. I thought the chairman could have. I think the chairman can have all the time he wants. I'd just like to conclude by saying, and I just ask for a second, just a second. What our committee is engaged in is nothing but a partisan attack on Secretary Clinton with an effort to harm or undermine her presidential campaign. That's all it is. Get the chairman of the Intelligence Committee to release the documents to you. No one is withholding it. The Intelligence Committee has jurisdiction over agencies, including the FBI. They release their information. They have a process. You have appealed to that process. Let's wait for that process. Ask him why he's not taking a vote to give you access to these documents. You're making it look like there's some conspiracy or some terrible thing happening when it's really nothing but a partisan attack on Secretary Clinton.
I think the gentlewoman, and I guess with some indulgence, where I have a problem is when they redact information that is deemed unclassified. I don't understand that. It makes no sense. And classification is one issue, but when they redact information that has already been designated as unclassified, I believe that Congress should be able to see that.
Mr. Chairman, may I respond?
Sure. Yeah.
In the hearings that we've had, the witnesses have testified that personal information that has been redacted has been to protect the privacy of people and personal information. Now that's on record. But in the classified section, we can have more of this clarified.
Thank you. And I appreciate the dialogue back and forth. Now let's recognize the gentleman from Ohio, Mr. Jordan, for 5 minutes.
Mr. Herring, let me just follow up where the chairman was. So did the FBI make the redactions dealing with personal identifiable information?
We did, yes.
You did. That's what I figured. Okay, Mr. Herring, you've said we don't have all the 302s. We don't have the whole file. And what you did give us, as you just pointed out, had lots of redactions.
Yes, sir.
And the chairman invited you to a briefing last week in a classified setting, which you said in your opening remarks where you'd like to discuss this information. So who told you not to come to the briefing? Because the chairman was there, I was there. In fact, every single Republican member was sitting there waiting anxiously for you to come do what you just said in your opening statement you wanted to do. So why didn't you show up?
So let me say a couple things here, if I could, just to sort of be clear. As far as the 302s and what we've provided and what we haven't provided, are a lot of 302s, there are dozens of them, and we prioritized up front what we thought were the most important ones. And so those are the ones we gave.
But you got them all, don't you?
A couple of weeks. We do have, and we're working on the others.
So you can get the paper, you can give it to us, or frankly, you could have told us what you just told us right there. You could have told us that last Wednesday, but you didn't come. So why didn't you come?
So I actually want to address it in the classified setting, if I could. There was certainly
someone tell you not to come, Mr. Herring?
There's some conversations between me and some of the committee staff about what the briefing was going to be about.
No, I'm asking, did someone tell you not to come? You were invited, we were all waiting. We don't have all the 302s, we don't have the whole file. You've told us you made all the redactions. We were going to ask you about that. We were going to do it in a classified setting, which is what you preferred, what you want, what you've told us today you want, and someone told you not to come. Who told you not to come?
It was my decision, but I'd like to explain it away in the classified
Wait. You decided on your own? You didn't consult with anyone else?
Certainly consulted with the director's office.
And the director said, it's up to you, Mr. Herring. I'm not going to decide. You're going to decide? Really?
So a lot of it has to do with what the discussion was going to be in the classified briefing. And I think there was some confusion, at least on my part, about what the expectations were and some of my conversations with committee staff last week.
Do you have any other discussions? Just you and Director Comey talked about this? You talked to anyone else?
Certainly. We have our general counsel's office, the Department of Justice. There are a number of people.
Mr. Herring, was this case different? You said you've been around the FBI 17 years. You're now the acting director for legislative affairs. Was this case different?
I think this case is different in a lot of ways.
A lot of ways?
I do.
Can you tell us, can you give me some, why? I know it's different in a lot of ways. How about this difference? You ever had a case in your 17 years where the subject of your investigation's husband meets with the Attorney General just a couple days before you're going to interview that individual in your investigation? You ever had that happen in your 17 years?
No, sir.
That's certainly different, isn't it?
Yes, sir.
Yeah, you ever have a case in your 17 years, and we appreciate your service, you ever have a case where the Attorney General announces publicly that she's going to follow the recommendations of the FBI, even though she has no idea what those recommendations are going to be, based on, you ever have that happen in your 17 years?
Not on one of the cases I was assigned.
Yeah. Well, I don't think it's ever happened because the Attorney General told me she's never done that until this time. Certainly. You ever in your 17 years, you ever have a director of the FBI, you ever have them do a big press conference, walk through all the wrongdoings of the person under investigation? You ever have that happen, a big press conference before, and then make this big announcement? Or normally the FBI just kind of announces whether they're going to prosecute or not, right? You ever seen that before?
I mean, you certainly have press conferences, not quite like that one.
Not quite like that one. That's exactly right. And then have you ever had this? Now, maybe this happens, but Mr. Cummings said in his opening statement, Republicans didn't like
pursuant to investigation of Secretary Clinton. What's the number there?
I know that it's somewhere probably in the neighborhood of the 50,000
Just 50,000
so far.
given to this committee pursuant to an investigation of Secretary Clinton. I thought we said earlier there were about 168,000.
Those were, that's not, those, we have 23 different requests from this committee.
Okay, let me ask you, how many documents have you provided this committee pursuant to our investigation of Colin Powell?
I believe we provided this committee the 3 documents that the
Great, okay.
that the FBI.
Okay. All right, 50,000 to 3. I think it shows you the lopsided focus here. To your knowledge, has anybody at State Department ever picked up the phone and called AOL about these questions?
As I said in response to your earlier question, sir, it is we cannot get records of another individual from their provider. They have to do it.
I don't get this. This is ridiculous. This is the National Archives asking you to contact AOL, but you didn't do that. You asked Secretary Powell to contact AOL. He didn't do that. Now, you remember Secretary Powell served at a very critical time. There was dubious information provided about weapons of mass destruction in Iraq that led this country to war. There were some very, very important decisions of enormous consequence in this country at that time. And yet, we are totally silent on that inquiry. Meanwhile, we've got 9 investigations and counting on Secretary Clinton. This is not how this is supposed to work. This committee is supposed to be pursuing the truth. And I have to say that your non-cooperation here, even though it's at the advice of counsel, is, I think, putting the country at a particular point of vulnerability with respect to this investigation. And I just think if we're going to do this, if we're going to put our secretaries of state and our national leaders under the microscope, it shouldn't be just, it shouldn't be just the Democrats under investigation. And that's what I feel is going on right here. That's what I feel is going on right here. And that we've got tens of thousands of documents produced as a result of an investigation of Secretary Clinton, and we've got three documents that you say you've provided with respect to Secretary Powell. This is a sham. This is a sham. And I think the comments of the Republican leader earlier indicated that this whole attempt was to rip down Hillary Clinton and ruin her reputation. That's what this is all about. And we're spending. Look, I didn't have to spend any taxpayer money to get Colin Powell's admission that he used a private email system, an unclassified system, to go on AOL that was hacked 92 million times during his tenure. I didn't have to spend taxpayer money to find out what he did. All I had to do was read his book in his own words. And here we are, like I said, the 9th investigation. Now we're going to have another one, I expect, just to rip down Hillary Clinton. And the only reason that we're doing it is because she's running for President of the United States. That's the plain and god-awful truth. That's what this is about. And it's a shame. It's a shame. I yield back the balance of my time.
I thank the gentleman. I would highlight that the letter that we sent in January of this year asked the State Department for the current and past 4 secretaries of state. And I'd ask unanimous consent to enter this record dated January 19th, 2015. Sorry, I said this year, 2015, into the record.
Mr. Chairman.
Would that be 16 or 15?
Chairman, you.
Sure.
It's on the document, and I'm wondering, what was the follow-up on that from these folks?
It's incomplete. We don't have all the information yet. We have some, but we don't have
on Colin Powell and Rice and.
We asked for the current and past 4 secretaries of state.
I just want to know what we've gotten. I mean,
well, let me get that from the staff. It's a very appropriate question, and we will follow up. But it is incomplete. We did ask for it, not just of this current one, not of the past one, but the past 4. So. Can you?
What about AOL? Can we ask them to get us that information? I mean, the fervor which we're going after Hillary Clinton, it seems like we have so much power over the subpoena. It seems like we would want to get those records. Chairman, willing to go to AOL and
For
try to
first
get there.
order of business, I ask unanimous consent to enter this into the record.
Having
Without objection, so ordered. And I will work with you to recover those emails. I just want the federal records. I just
all of them. All of them.
All of them.
Yeah.
If we have to use the power of the committee to extract them and using subpoenas, I'm willing to do that.
You hear that, Mr. Kennedy? We're going to be working with you to get that done.
Yes, sir, Mr. Ranking Member. Could I add one thing?
Sure.
In consultations with representatives of the 4 prior Secretaries of State, neither Secretary Albright nor Secretary Rice used email. They have certified that to us.
Yes, and that's my understanding. I would also note that we rely heavily on the Inspectors General, and there is an Inspector General report on this, and it's very frustrating when the Inspector General, impartial, in there to do their job, the only person that refuses to interact is Hillary Clinton. And that's just a fact. That's not political. It's just a fact. She won't cooperate with the Inspector General. Even the State Department asks for an electronic copy that was never provided. There is but one investigation that we are conducting relating to what's happening here and these federal records and the potential destruction. We have other inquiries of the State Department, ardent embassies, embassy security, things that we're doing in very much a bipartisan way. But let's be careful in how we represent us. There is one investigation.
And that's of Hillary
We
Clinton.
were quiet until the FBI, and when the FBI testified, they didn't even ask these questions. It begs the question, and we have a job to do, and we're going to do it.
Mr. Chairman, I know we want to move on. I'm looking forward to working with you to get all the records. I think the American people deserve that.
Yeah, I agree.
And I don't want it to be a one-sided, single investigation of Hillary Clinton, because I do think it goes against the integrity of the committee.
I hear you.
Mr. Chairman,
Yes.
just in terms of Ambassador Kennedy's last comment, that he reached out to Secretary Albright and Secretary Rice. Secretary Rice served between 2005 and 2009. That was well into the era of email. Have you checked, did she have a personal account or any? I mean, they certified they didn't use email. I find that very hard to believe.
I have spoken personally with Secretary Rice's attorney, and that was his response, sir.
Okay.
But I believe he was asking about Secretary Albright, too.
Oh, I was asking about Secretary Rice,
But both.
2005 to
All right,
2009.
now I recognize the gentleman from Florida, Mr. Miker, for 5 minutes.
Well, again, for the record, Ambassador Kennedy, you did say that they did not use, the 2 previous did not use email. Is that correct?
That is what we have no records.
Okay.
And we have talked to their representatives, Mr. Micah, and to confirm that.
Okay. So, again, the way we got into this, folks, is we had a legitimate investigation into what took place in Benghazi, and actually all of this was discovered sort of by accident. But the fact is, Mr. Finney, how long have you been in your position with State over correspondence and records?
Yes, sir. I came to the State
I
Department.
can't hear you real loud.
Real close. There you
Yes,
go.
sir.
What year?
Yes, sir. I came to the State Department in July of 2006.
And the fact is, in 2011, actually, you were first alerted to the use of the secretary. Here's a picture of the secretary. This is an article from a publication that said you identified in 2011 or raised questions about how the secretary was operating. And I guess, did you go to Lang and Lang made you aware that she was using a private server? How did you find out she was using a private server? You asked the question, was she using a government account? And the response came back, no. Who told you that?
That was told to me by individuals within SES-IRM, a specific person I couldn't remember.
But that goes back some time ago. Now, you have an important responsibility. You're supposed to keep the records and correspondence when they leave office. And then you meet with folks. I mean, these are members of Congress. We all have the same obligation. we are custodians or trustees of information, and some of that we cannot take with us. You're not supposed to. In fact, I think it's against the law. Isn't there a statute prohibiting taking that with you? Is that?
Yes.
I'm not an attorney. Okay, yes.
Yes, sir.
You met with Secretary Clinton's staff, did you not? Did you meet with the secretary or just her staff?
Met with her staff, sir.
And is it Abdeen? Was she there and you told them the obligations of what they had to turn over? Did you provide them with that information?
First of all, exactly who was in that meeting, I'll have to go back and...
Okay, but Abdeen, was she there?
Again?
Yes, okay. But you told them what the obligation under the law and requirements of the State Department are returning information.
Yes, sir, myself and the agency records officer.
At the time, did you mention anything about what was on a private server of business that may have been conducted from in an official capacity?
Again, had no idea of a...
But you told them anything dealing with public information that should be part of State Department documents that you are the custodian for should be turned over to you, correct?
We briefed them about what their responsibilities are, sir.
And then how long did it take? We heard again, this request went in as they left. I'm told it took 2.5 years for the first so-called data dump. Is that correct, Ambassador Kennedy?
Could you?
How long before, when did you get the first dump of information from the Clintons?
In December, sir.
Of last year?
December 14.
14? But it was sometime after they left.
That is correct, sir.
2 years after they left. I had 2.5 years.
Sir, if I may.
No, I have a limited amount of time. And were you told at the time that that was all the information? Did anyone tell you that that's all the information they had and data and emails?
If we're talking about the delivery in December of 2014 of the 55,000.
Was there a transmittal document?
We received.
The transmittal document say this is all we have or this is everything we found?
I believe it's something.
I'd like to see that transmittal document too. But then you tell me the FBI has been dumping additional data to you all, records that they found that they did not provide, right?
What the FBI essentially did, to the best of my understanding, sir, is use forensics to go.
I know, but my point is that there's a requirement under law to turn over the documents, and this gentleman is responsible. He told them what to do,
right,
and the terms of the law are the regulations, and they were to comply. They did not.
They according to their
I want to
attorney,
see the documents. They obviously didn't, and we've gotten dumps of additional information according to the testimony you gave here today. I want to know about the destruction of the hammering of the Blackberries. Those were personal Blackberries that the Secretary owned. Is that what I'm told? They were not. That was not federal property. Do you know? You're the custodian of the properties or the data. Should they have turned the Blackberries over if they were government Blackberries?
First of all, sir, I'm responsible for the records of the individuals who are.
But they also have to give over property. You don't know anything about the hammering of the Blackberries or whether they're personal. And I also I'd like to know for the record too, the staff Blackberries that were turned over, if any of those were not turned over, if they were destroyed too. Mr. Chairman, I request that information. I yield back.
Thank you, John. We'll now recognize the ranking member, Mr. Cummings.
Thank you very much, Mr. Chairman. Mr. Kennedy, Ambassador Kennedy, I am extremely concerned, as I've said before, about this whole issue of classification. You've got people being accused of crimes and a lot of it, and it becomes very significant what's classified and what's not classified. I think would you agree with that? It is significant.
Classification is always significant.
Yeah.
Yes, sir, Mr. Ranking Member.
So, Mr. Kennedy, I want to ask you about the instances when experts from different agencies disagree about whether information is classified. I have an email here dated April 10th, 2011. It was written by someone from the State Department Operations Center based on a phone call with Christopher Stevens, who was a special envoy to Libya. It's up on the screen. In the first line of the email, it says, and I quote, SBU per Special Envoy Stevens, end of quote. What does SBU mean?
It means sensitive but unclassified, sir. Unclassified.
So this email was explicitly marked unclassified, is that right?
Yes, sir.
And it appears that the Special Envoy Stevens considered this information unclassified, is that correct?
That is correct, sir.
So anyone reading this email would assume that it was not classified, is that correct?
That is correct, sir.
The problem is that at some point after the email was sent, the intelligence community came in and claimed that it was classified. On September 15, 2015, the State Department sent a letter to Senator Corker explaining that the intelligence community was wrong. The letter stated, and I quote,
I'm not changing my deposition one item, but two things, sir. One is I was not brought up to date immediately on the fact that my colleagues and staff had come across this one email thing and then were researching through the material. That was not brought to my attention much later.
Here's what I want to get to. The FBI released their report last Friday. They say on page 15, during the summer of 2014, State Department indicated to Cheryl Mills a request for Clinton's work-related emails would be forthcoming. And in October of 2014, the State Department followed up by sending an official request to Clinton asking for her work-related emails. Now, you just said in February when you were under oath and you were deposed in front of the Benghazi Committee that you never tipped her off. But somebody tipped her off, because during the summer of 2014, she got a heads up that this letter was coming. Do you know who tipped her off?
No, sir, I do not.
And it wasn't you, Ambassador Kennedy?
Well, not to the best of my knowledge, no, sir.
Ambassador Kennedy, were you interviewed by the FBI?
Yes, sir.
Ambassador Jacobs, did you tip Hillary Clinton off in the summer of 2014 before this letter?
No, sir, I did not.
Were you interviewed by the FBI?
No, I was not.
Ms. Lang, did you tip Hillary Clinton off or Cheryl Mills off in the summer of 2014?
No, I did not, sir.
Were you interviewed by the FBI?
No, I was not, sir.
Mr. Finney, did you tip Cheryl Mills off?
No, sir.
Did you tip Hillary Clinton off?
No, sir.
Were you interviewed by the FBI?
No, sir.
So somebody who was interviewed by the FBI told the FBI we tipped her off. Have you done an investigation, Ambassador Kennedy, and who might have tipped off? I mean, here's what this gets to. Once again, Hillary Clinton gets treated different than anybody else. She got tipped off. I don't think Ambassador Powell got tipped off. Have you started an investigation, Ambassador Kennedy, and who might have tipped Hillary Clinton off before she got the letter requesting these documents?
I have not.
Any idea who did tip her off?
No, sir.
I yield back.
Thank the gentleman. We'll now recognize the gentleman from Pennsylvania, Mr. Cartwright, for 5 minutes.
Thank you, Mr. Chairman. Ambassador Kennedy, I want to ask you some questions about the 3 emails out of the 30,000 that FBI Director Comey referenced that supposedly had some kind of classification markings on them. And, of course, if anyone's scoring along at home, that means 29,997 emails produced with no markings whatsoever, not even defective or incorrect classification markings. I want to talk about the manual on how you properly mark a classified document. Executive Order 13526 and the directive implementing it require classified documents to be marked in a certain way. The document must identify the original classifier, correct, Ambassador Kennedy?
That is correct, sir. There is, in effect, a 4-line marking that must go on all
classified. It must identify the
documents.
agency of the office of origin, correct?
Yes, sir.
Must identify the reason for classification, correct?
Yes, sir.
It must identify the date for declassification, right?
Yes, sir.
And classified documents typically have to have a banner or a header at the top and bottom that say classified along with the level of classification. Am I correct in that?
Yes, sir.
Okay, so 5 different requirements in the manual, and the 3 emails that Director Comey testified about had none of these indicators. Am I correct in that?
That is correct,
Not
sir.
one of the 5 required marking requirements. Am I correct in that?
That is correct, sir.
Okay. The three emails had none of them. As a result, Director Comey, sitting where you're sitting right now, testified that it would be reasonable for somebody looking at a document with none of these required markings immediately to infer that they were not classified. Are you aware of that testimony?
I am aware of it, sir.
And do you agree with Director Comey that someone who is familiar with properly marking classified documents would reasonably consider such a document without any of these 5 requirements not classified?
I fully agree with the Director.
Now, State Department spokesman John Kirby said that the parentheses C markings, the one that refer to confidential, the lowest level of classifications, on those 3 emails, John Kirby said those markings themselves were in error and they were not, quote, necessary or appropriate at the time they were sent as an actual email, unquote. Is that your understanding as well?
Yes, sir.
Well, I want to show you one of these emails, and it's dated August 2, 2012. The marking, and we have that up on the screen for you as well. Do you have that, Ambassador?
I do, sir.
All right. The marking that Director Comey referred to is the C in parentheses at the beginning of the email, and that's the marking that the State Department said was a mistake. Do you see that?
Yes, sir.
And then 4 paragraphs follow. Do you see them?
Yes, sir.
Each of the paragraphs says SBU, and we've covered that in today's hearing. SBU means sensitive but unclassified, right?
That means, yes, sir, and that means it does not have to be moved in classified channels.
So every one of these 4 paragraphs in the bulk of this email are sensitive but unclassified, right?
Yes, sir.
Okay. So this email is in fact unclassified, and it always has been, hasn't it?
Yes, sir.
Now, did the FBI consult with you about the classification status of this email?
They did not consult with me personally. I know the State Department did provide some input to the FBI, but their decisions are their decisions. Their writings are their writings.
When you say their, who do you mean?
The FBI, sir.
All right. Do you know why the FBI did not consult with you about the classification status of this email?
I would have to check, Congressman, to see if they consulted with someone else at the State Department. I know they did not consult with me. But as you correctly point out, the subject line there does not have any classified material in it, nor does the text of that. And even the redactions that are there, the redaction B5 is a redaction for deliberative process, not for classification. So this document is unclassified.
I thank you, Ambassador, and I yield back.
Thank the gentleman. We'll now recognize the gentleman from Michigan, Mr. Walberg, for 5 minutes.
Thank you, Mr. Chairman, and thanks to the panel for being here. Mr. Feeney, when did you first become aware of the extent to which Secretary Clinton relied on private server emails to address her conduct, her responsibilities in State Department business?
Sir, I couldn't give you the actual date and time frame, but I do know that when we had started receiving the actual documents at the State Department, that's when I come to realize that she was using another device other than...
Do you recall a January 2009 FOIA request for correspondence related to Secretary Clinton?
Sir, without looking at the case, I couldn't specifically know.
But you would identify the fact that you have logs, so if you can't recall it, right here, there's a January 9th of 2009 request for information on correspondence from Secretary Clinton. So you would be able to go back, whether you recall it right now.
Yes, sir. If we received it in the Executive Secretariat, then we could go back.
On the basis of that, did you review email correspondence from the Secretary in putting together the response to this January 2009 request?
No, sir, because we did not have emails. She did not have a state.gov account, so all we could search was our records that we had, sir.
So you then, as I understand it, did not realize the extent to which the Secretary was using her private email server. And on the basis of that, you're saying you couldn't do anything about it?
Again, sir, did not know that she had a server or other email accounts that she was using until we received it in the department.
Well, how was if this request was made in 2009, how was the department able to close a request for correspondence covering Secretary Clinton when the department did not have access to all of the email correspondence from the Secretary?
Again, sir, I would have to see the specific request and see what they were asking and see if it in fact was received.
But they did ask. You've got a log of that.
Again, sir, I would have to see if we in the Executive Secretariat received it, because when FOIAs come in, they do not come directly to the Executive Secretariat. They come to a bureau.
Now that you know, is the department reopening requests that would encompass the Secretary's emails that were closed prior to disclosure, that she was using her private server, private emails for conducting official business?
I'm not able to answer that question, sir, because I'm only responsible for the Executive Secretary.
Who would be responsible for that? Mr. Kennedy, now that you know it?
Now, that is why, Congressman, that we have posted all of the 52,000 emails we received on the State Department's public website, so that if there was an email that we now have, but we did not have then, and therefore since we did not have it, we were telling the truth in response at that moment. If anyone thinks that one of their inquiries did not get a full response, we have posted all that material, all the 52,000 odd documents, to our public FOIA website in a searchable form, so that we can be, in effect, retroactively responsive to any earlier inquiries that we did not have records of then.
Wow.
So we are at 50. Anyone who had made a request, they can now go to our website, and all the 52,000.
So we got the requests.
Pardon me, sir?
We have the request then on the website. That's what you're saying.
No, we have the documents on the website. All 52,000 documents are on the website. And therefore, if we did not respond before, because we did not have the record then, and we have the record now, the 52,000, we put all 52,000 of them up on the State Department public website, accessible to every member of the public.
Again, Mr. Chairman, I think this is the reason for this hearing, isn't it? The sloppiness, the messiness, and the ability for a Secretary of State to do something that shouldn't have been done. Mr. Feeney, do you recall a FOIA request from August 27, 2010?
Secretary come to answer, so hone those questions, and hopefully that'll happen in the next week or two.
Thank you, Mr. Chair.
Thank you. We'll now recognize the gentleman from South Carolina, Mr. Gowdy.
Thank you, Mr. Chairman. Mr. Finney, I had a series of questions for you that I'll submit to you in writing. I'm going to have to deviate from what I'd planned to do because of the ranking member's opening statement, which I found instructive, if not predictable. So I want us to summarize for just a second. Secretary Clinton said she followed all State Department rules and regulations, but the truth is she did not. Secretary Clinton said her unique email arrangement was approved by the State Department, but it was not. Secretary Clinton said she used one device for convenience, but she did not. Secretary Clinton said she did not send or receive classified material, but she did. She said she turned over all of her work-related emails, but she did not. She said her attorneys personally reviewed each email, but they did not. So when faced with a series of demonstrably false statements, utterly impeached by both fact and logic, the ranking member did what lots of criminal defense attorneys do, which is blame the investigator. And when that didn't work, they throw the Hail Mary pass of all criminal defense attorneys. Other people did it too. Which brings me to General Colin Powell, one of the most respected people in our country's history. You know, Secretary Clinton told the FBI, and I'll concede, she says different things to the public than she says to the FBI, but she told the FBI that Colin Powell's advice had nothing to do with her decision to set up her unique email arrangement with herself. Now, I'm going to say that again in case anybody missed it. Secretary Clinton told the FBI, under penalty of not telling the truth, that Colin Powell's advice, email, had nothing to do with her decision to set up that unique email arrangement with herself. Now, I will say this in defense of Mr. Cummings. I understand why he may not believe her. I understand that. I understand why he may have credibility issues with anything that the Secretary said. I get that. But I think it would have been fair when you are using your opening to criticize Colin Powell to at least point out the person you're trying to defend doesn't even say Colin Powell was the impetus behind her decision to have that unique email arrangement with herself. So let me ask you this. Secretary Clinton was asked, because she frequently says 90 to 95% of her emails were in the State Department system. Have you heard her say that?
Sir, I can't recall.
Well, it won't take you long to find it. She says it a lot, or she said it a lot. And then she was asked, who told you that? Who told you that 90 to 95% of your emails were in the State Department system? You may find her answer interesting. We learned that from the State Department and their analysis of the emails that were already on the system. We were trying to help them close some gaps. I like the word gaps. I guess if you consider the Grand Canyon to be a gap, then yes, there were some gaps in her email. Did you have 90 or 95% of her emails on your system?
Again, sir, the only emails we would have is what has been provided recently, which was that 55,000 that we got.
Well, no, I'm going back before that, Mr. Finney. She said you already had them before she gave them to you. You already had 90 to 95%. Was that true?
Again, sir, the emails that we're looking at, talking about the state.gov emails, she did not have a state.gov account. And as far as the emails that we received from her came at that time frame when it was turned to the department and it was processed by a bureau.
But she made this contention before she ever returned them. She said you already had 90 to 95%. She was just helping you fill in some gaps. If you had 90 to 95%, why weren't you complying with FOIA?
Again, sir, what I have in our system is what received by a bureau.
Let me see if I can put that in South Carolina terms that I can understand. If she said that you already had 90 to 95% of her emails before she ever returned them, that ain't true.
Sir, if I may say this, unless she's talking about the files that were sent to other individuals within the State Department, sent to their state.gov account.
Well, how does that capture personal-to-personal emails? And how about the 14,000 that she didn't turn over? Did you have those?
Again, sir, what you're talking about here.
Oh, I understand her position. Yes, the fact that I didn't keep them doesn't mean that whoever I sent it to didn't keep it. I get that. What if it's private to private? How are you supposed to have Sidney Blumenthal's emails if it's private account to private account? How do you have that?
Sir, if you look at what we are doing today, in accordance to the Federal Records Act of 2014 that was amended, it requires that if an employee uses their Gmail account or private issued account, they're required by law to send that email to their state.gov account. That was amended in 2014, and that is what I'm briefing and the State Department briefs today.
That sounds like it was a couple years too late, but I'm out of time.
Thank the gentleman. Now recognize the gentlewoman from the Virgin Islands, Ms. Plaskett, for 5 minutes.
Thank you very much, Mr. Chairman, and good morning to you all. Thank you for being here. I believe that the ranking member, and I don't want to get into his head, was pointing out the disparity between the two secretaries, not to absolve Secretary Clinton of her responsibility, because as we've all seen in testimony that she's given, that she has taken full responsibility for her own emails. but to point out the disparity and the bias in this own committee in how it treats different secretaries of state. I want to ask you about some emails that I hope you have received from other secretaries. Ambassador Kennedy, do you have any emails from the Secretary of State who was the Secretary of State in December 2002 or January of 2003?
No, no, I do not.
And that would be Secretary Colin Powell, would that not?
Yes, ma'am.
Those are very interesting emails, I would think, because that would be the 2 months before he gave testimony on February 5th, 2003, before the United Nations, saying that there were weapons of mass destruction, which has resulted in the death of almost tens of thousands of Americans with the Iraq War. But this committee, which says that it's investigating these breaches and these emails because they're concerned with the lives of Americans, don't seem to be concerned with the email traffic that went on that precipitated that testimony, which led us to war. They're not concerned at all with those emails, but they're concerned with Secretary Clinton's emails. How many emails have you received from Secretary Colin Powell?
The only ones that I'm aware of that are in our possession are the documents that you just handed out, that we received via the FBI in an interchange between Secretary Clinton and then former Secretary.
What you're doing, you're being forced to use the classification label.
Exactly. We need the authority to have a foreign government information exemption, and we have asked for that from
Would this
Congress.
require a statutory change?
It does require statutory change.
Mr. Chairman, please note that, because I do think that is important to know. I'm not sure the committee knew that. That testimony is important for me, and I think it comes out, I think, at a good time when we're trying to find out not only what happened, but what to do about it. Let me ask you finally, have you directed these 1,000 people to do anything about, like, for example, deleting this classified information? Remember, retroactively classified from their systems. Have you asked them, since it's now classified, to make sure it's gone from your system? And indeed, what can you do about it if it's retroactive?
We take certain steps with the highly classified, but for the FGI material, we have not taken that step.
Don't you think you should?
Because those are within our system, and
You mean those cannot be shared anyway?
We have now marked them so they were not going to be released to
Could I just ask one? Should they be deleted or not?
We would not delete them. We would transfer them to another system because we do not delete federal records.
Thank you, Mr. Chairman.
Thank you. And that's a good takeaway. I appreciate, Ambassador, you're sharing that perspective and driving that home with us, so thank you again. We'll now recognize the gentleman from Georgia, Mr. Heiss, for 5 minutes.
Thank you, Mr. Chairman. Ambassador Jacobs, when responding to a FOIA request, who in the State Department is responsible for determining what is redacted?
Thank you for the question. It is the responsibility of the people who work in our FOIA office, which is in our Bureau of Administration, to determine what is redacted.
Who is the lead person, the head? Where does the buck stop?
It's a number of people who are trained and skilled in the FOIA law who do this. There's not one particular person.
Could you provide the names of those individuals for us?
I can.
Okay. Is there a specific criteria that they use to determine what is redacted and what's not?
Yes, sir. It's basically the FOIA law, the exemptions that exist under the FOIA law.
Okay. When responding to a request from Congress, who is responsible for determining what is redacted?
There are different standards that are used for Congress, sir. I think that you get more information than we would release to the public ordinarily.
I'm not so sure that we do. How is the process different between a FOIA request and a congressional request when it comes to what is redacted and what is not?
I think we are guided by the different agreements, arrangements that we have with Congress. Certainly, for releases to the general public, we follow the FOIA law, and I think with Congress, perhaps there are different procedures that we follow.
Do you know what those different procedures are? That's my question.
I'm not exactly sure of all of them. I'd have to get back to you, sir.
Would you get back with me and clarify that issue?
I will do that.
You have been really in charge of your role as transparency coordinator in the State Department. Do you believe the State Department is being transparent?
Yes, sir, I do. I think to the best of our ability, we are committed to openness and to, especially under FOIA, to releasing whatever we can.
Okay, but the question goes beyond FOIA. It goes to congressional requests as well. And it's extremely frustrating. Just for example, I know it's with the FBI, but they just released a 58-page summary to the public, publicly released the other day. And I was scanning through it. In fact, I have a copy of it right here. And listen, I understand, Mr. Chairman, I understand fully when there are potential compromises in our national security. I understand the need for redacted material. That is not even in question, I don't believe, with anyone. But the current process seems so arbitrary and just all over the map where and how redactions take place. And frankly, this is an issue that goes across the entire executive branch. And the questions out there are multiple. I'm looking right now with the summary that came out the other day. Ms. Clinton's birthday is redacted. I mean, what is the potential national security threat in that? You can go on Wikipedia and find it. In fact, I did.
Congressman,
that is no, sir.
If I could just ask.
No, I'm not asking you a question right now. I'm expressing frustration in the whole process. The very next sentence, it mentions Ms. Clinton's 5 attorneys, 4 of them by name, but 1 of them is redacted. We seem to be all over the map, and quite frankly, the end result appearance, at least, and I'm not making an accusation, but the absolute appearance is that obstruction is involved many times when it comes to what is redacted and what is not. And how in the world can we do our job of oversight when we're not given the requested information that we need to do our job, or when what is received is so redacted it's difficult to determine what has been really given us and what's not been given. So, Mr. Chairman, I think any reasonable person would frequently look at the material, whether it's through a FOIA request or a congressional request, and have great concerns that information that is needed for whatever requested purpose is not being provided accurately. And this, Ambassador Jacobs, raises a question as to transparency at state as well as other departments. And so, Mr. Chairman, I would just, I hope that we can not only get the material that we've requested, all of it, but I hope also that transparency can occur. It is America that's suffering when we're not allowed to do the job that we've been tasked to do here in oversight. And with that, Mr. Chairman, I yield back.
Before he yields, if the gentleman yield to me.
Yes, sir.
Ambassador Jacobs, you're heading up the transparency, you're the transparency coordinator. What is it that you believe Congress should not be able to see?
Sir, thank you for the question. I am not completely familiar with all of the agreements and arrangements that we have. I do.
But
know
why
that
should there
in
be
general,
any agreements and arrangements?
Well,
what could Congress not see? You were brought in by Secretary Kerry, right, to be the transparency person.
Yes,
so
sir.
you're champion of transparency. What is it that Congress should not be able to see?
I think that Congress should have access to all of the information that they are entitled to. I believe that there are certain restrictions that are
Give me an example. You've been in Foreign Service for 33 years, so give me an example of something that I, as the chairman of the Oversight Committee, or Mr. Heiss, should not be able to see.
Highly classified, compartmented information, perhaps, if you don't
Like
have the proper clearance.
With SAP information?
I assume so, unless you have the proper clearance.
What else?
information related to privacy, personally identifiable information?
Sorry, got that one wrong. Sorry. We're not, Congress is exempt from the Privacy Act, so try again. What else?
Sir, I really believe that you should have access to whatever information.
But when you get this thing, it's sent to us and it's chock full of redactions. Why?
Are you referring to
No,
information?
we don't
that we've
need the
sent or the
whispering here.
FBI?
We'll allow you all to do it. You don't need to kind of whisper in her ear and tell her
No.
what the right answer
The
is.
question was whether this was information from the FBI or from the State
I'm asking from the State Department.
What I can do is offer to come up and with a
You're here right now.
I understand, sir. But this is
Ambassador Kennedy, come on, you've got probably the most experience here. Give me an example. What is it that Congress should not see?
I think that not every member of the congressional staff should be entitled to.
I didn't ask about staff. I said members of Congress.
Okay. Then, Mr. Chairman, the only thing that I believe is valid is internal executive branch deliberations leading to a decision.
And that
I think that is a prerogative of the Congress to have its deliberations secret, and it's a prerogative of the executive branch to arrive at a position and then come up and defend that position wholly and fully before the Congress, but not necessarily all the internal puts and takes that went into it before an executive branch decision was made, sir.
And there is the President can claim executive privilege. There's a process to do that where the President actually has to sign a document invoking that executive privilege. Mr. Cummings.
Yeah, just real quick. Ambassador Kennedy, I'm just curious about something Mr. Heiss just asked. Why would a birthday be redacted? I'm just curious. You were trying to answer it, and I was just wondering what you were going to say.
We think that names of spouses, names of children, birth dates, social security numbers, that information is not necessary for the conduct of any business, and there is always the possibility of spillage. I am not accusing any member of Congress or any staff member, but we desperately try to make sure that information that is protected under the Privacy Act is used only on an absolute need to know.
The Privacy Act does not apply to Congress, and what you're doing is you're conflating FOIA with congressional requests. We have a SCIF. We deal with classified information. We've exhausted this for right now. Let's now recognize the gentlewoman from New York, Ms. Maloney.
Thank you, Mr. Chairman and Mr. Ranking Member. I would say that what this hearing shows very clearly is that the classification system is broken and it needs to be reformed. This is something we could work together on in a bipartisan way. And in fact, I will introduce this week a sense of Congress that the classification system needs to be reviewed and needs to be reformed. I have here an email that the State Department marks as sensitive but unclassified, clearly calls it unclassified at the top and at the bottom, and yet the FBI called it classified. Now, there's clearly something wrong here. Now, this memo was a memo written by a senior diplomat, a Jeffrey Feltman, and he was the Assistant Secretary for the Bureau of Near Eastern Affairs, a senior diplomat. It's his personal email, and he calls each paragraph that he wrote SBU, which stands for sensitive but unclassified. Now, if you look at the State Department's Foreign Affairs Manual, it clearly says sensitive but unclassified information is, and I quote, not classified. So I would like to ask you, Mr. Kennedy, if you received this from a senior diplomat whose judgment you trust, and he marks unclassified at the top, at the bottom, and 4 other times in the body of the document, would you think the document is unclassified?
I think the document is unclassified, but, Congresswoman, if I received a FOIA request and the text contained foreign government information that had been shared with us in confidence, I would not wish it releasable to
We
the
heard
world.
that. We
And so
heard that.
That is the underpinning of our discussion, ma'am.
We hear that. The chairman hears it. We're going to work on it. But my point is there is something clearly wrong with the system where an individual is charged with criminal activity because they receive a document that's marked unclassified, 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 and then the FBI comes in and says, oh, it's classified. So the whole system of classification, in my opinion, needs desperately to be reformed. And I would say that every member of this panel on the Republican and Democratic side, if we receive this memo, we would think it's unclassified because that's what it's stamped. But this was part of what the FBI called classified at the time. And I see this as something that needs to be corrected and it needs to be reformed.
If I could, I fully and absolutely agree with you, and that is why we have been for years seeking the ability for a FOIA exemption that would permit us to make foreign government information exempt.
We heard what you said, but my point that I am making right now, although that's an important one, is that this system is fundamentally flawed when an individual, in this case Secretary Clinton, received an email like this one and is accused of criminal activity for relying on the judgment of an experienced diplomat that is trusted by the State Department.
I fully agree with you.
And I feel that that is really outrageous. I would say it's an abuse of power, it's wrong, and it needs to be changed. And we are the Government Reform Committee. We should start working on it right now. It is explicitly designated in, let's see, 1, 2, 3, 4, 5, 6 places as unclassified. And now the FBI is saying that is classified. Mr. Chairman, I ask unanimous consent to place this document in the record. I think it is a
avenue. You have to review those and apply.
If the chairman will indulge me one more question, and then I'll cease and desist.
Gladly.
Thank you, Mr. Chairman. Mr. Herring, were you told at any time before this hearing or at any other time during this process that this is highly political and you should cover up, obfuscate, evade, deceive, or not provide information to protect somebody from our scrutiny?
No, not at all.
Has anybody at this table?
Gentleman's time has expired. We have votes on the floor that are 10 minutes away. We have members who still haven't asked questions. Plus, we need to do a recorded vote. So we're going to have to leave it here and now recognize.
I appreciate the chairman's indulgence.
Gentleman from North Carolina, Mr. Meadows, for 5 minutes.
Thank you, Mr. Chairman. Mr. Herring, would you say that the FBI's investigation and the delivery of documents have been very systematic and principled?
Yes, as far as delivery of.
So there's no haphazard method of delivering documents?
The documents we provided to Congress, sir?
Yes.
No, I think it's been thoughtful and deliberative. And
Okay. Can you tell me why you didn't deliver the documents that the chairman asked for on July the 11th to the committee? You didn't deliver them to the committee. You actually delivered them to another entity, did you not?
That's correct. We delivered it.
Why did you not deliver it to the committee?
Well, because those documents contain classified and other sensitive materials and need to make sure they're handled appropriately.
All right. So are you willing to deliver all the unclassified documents to this committee?
So I think that
yes or no? Because you can't have the first statement without the second statement. If the reason you sent it there was because it was classified, are you willing to give all the unclassified documents to this committee?
So the documents that we
yes or no?
We will give so we've given certain documents to the committee already.
Yes or no? It is a real simple question. Will you give all the unclassified documents to this committee, since the reason that you gave them to somebody else was that there was classified documents?
So the documents.
Yes or no?
The documents have the restrictions on them.
Yes or no? Why would they have? Who placed the restrictions? You?
No.
FBI?
Yes.
So the answer is you place restrictions, so you're not going to give the unclassified documents to this committee.
So we've given this committee access to all the documents through.
That's not the question. It's a great answer to a question I didn't ask. Are you willing to give the unclassified documents to this committee?
All I can do is tell you that I'll take it back.
All right, so let me ask you another question, because you said that it was systematic. I went to the classified room, and there's two big binders there. One binder had some documents. The second binder that we got from the FBI had more documents than the first binder, and yet they were supposed to be identical. Would you say that was?
So I'd like to address this in the classified setting, if I could. I think
was that an oversight?
I think the details are important of what the differences are.
But we just asked for a second copy, so would that not be haphazard? It doesn't seem too methodical, because when we went page for page, they didn't match up. So who made the decision to give us a different set?
I'd like to address that in the closed session, please.
Well, let me just say this. There was 27 new emails. There was a number of different types of information that didn't seem to go, and I don't want to share anything classified, so you admit that the first set and the second set were not identical.
They were not identical. There were some differences.
Okay. So what were the non-classification agency equities that prevented the initial disclosure of the 27 emails that we got in the second batch?
Again, classified session, I prefer to discuss.
Were all of those from one agency?
I would prefer to address it outside of the setting.
Okay, I understand that all of those were from one agency. Is that correct?
Look, the whole issue is sort of the handling of classified information.
So what was the agency?
I don't want to get into that here in this setting. I'm happy to answer your question.
Well, I have one of the emails that was withheld that said that it was later marked unclassified / CIA use only. So was that your justification for withholding it?
I'm sorry, I'm not sure I understand.
Well, it said unclassified CIA only. So, Mr. Higgins, let me come to you. Did you read those emails that were in the second batch?
Sir, I'd prefer to answer any questions about the classification review in closed setting.
All right. So no reason why they were withheld.
I'd prefer to answer any questions about the classification
All right.
review in a closed
So I understand you're asking for those documents back. Is that correct? That's not classified. Are you asking for them back?
Sir, I'd prefer in a closed session to answer any questions about the classification review.
All right. Did Director Brennan talk to you about that, Mr. Higgins?
Again, sir, I'd prefer to answer those questions.
All right. I can see where this is leading. So let me finish by this saying, you have finished all the redaction. Is that correct, Mr. Herring, on what you gave us on the unclassified documents? The redaction, the copies that we got to see on those unclassified documents, are the redactions done?
For the ones that you all have,
yes.
They're
all
not
right.
necessarily.
So will you comply with the federal law to release those in 20 days according to FOIA law? I'll yield back.
Sorry, what was the gentleman's answer? What was your answer to that question?
The redactions are completed for the ones that are here with Congress, the ones we've released. We're working on the remaining 302s. The PII redactions for the remaining 302s all in process.
Well, what I believe Mr. Meadows is asking is that under FOIA, there's a 20-day requirement to respond to a FOIA request. Now that we know that they're all done, will you release those within the 20-day time frame?
So I'm not a FOIA guy. They're not all completed for the other 302s.
Are there any that are completed?
I'm sorry?
Are there any that are completed?
I don't know the status. Okay. I don't know the status of all the
We'll go into that tomorrow. We've gone past our time. Let's now recognize the gentleman from Pennsylvania, Mr. Cartwright, for 5 minutes.
Thank you, Mr. Chairman. Mr. Herring, I want to give you a better chance to answer some of my colleague Mr. Meadows' questions. First of all, your title is you are the Acting Assistant Director for Congressional Affairs of the FBI. Is that correct?
That's correct.
And you're in that post for how long?
About a month.
Did you say you used to work for Mr. Goodlatte?
I did a detail to the Hill, to the judiciary, for about 15 months.
Oh, okay. And was that reporting to Mr. Goodlatte?
Certainly did. I was actually technically assigned to the crime subcommittee, and Sensenbrenner was the chair of that.
And the Goodlatte we're talking about is the Republican chairman of the House Judiciary Committee, is that correct?
Yes, sir.
Okay. Now, you just were hammered with all of these yes or no questions, and I could see you having trouble with them. The trouble you were having, Mr. Herring, did not stem from your lifelong ambition to protect Secretary Clinton, did it?
No, sir.
No. All right. In fact, the pointed question that my good friend Mr. Meadows was going over and over about was, will you turn over certain documents, yes or no? You're unable to say yes or no because that's not your call. You have to take it back to the office and take it up the chain of instruction, don't you?
Yes, sir.
That's why you couldn't answer yes or no.
Certainly.
Well, how fair was it for anybody to hit you with that kind of yes or no question when you couldn't give a yes or no answer? How fair was that?
I'm here to answer the questions as best I can.
Yeah. And I wonder how fair it is to second guess the FBI, officers who are sworn to uphold, defend, and protect our Constitution, and not caring where the political chips may fall. When Director Comey came in and testified, up until the time he decided not to prosecute, he was universally applauded on both sides of the aisle, particularly on the Republican side of the aisle, for his judgment, for his service, for his patriotism in this nation. And then, when it was his recommendation, which he now says was not even close, not to prosecute Secretary Clinton for the way she handled her email, all of a sudden he is reviled, and all of his decisions, up and down, are being second-guessed by the Republicans on this committee. I agree with my colleagues. This is nothing but a show trial. It is nothing but political theater. And the only reason, the exceptional reason that this is happening is that a couple of months from now, people are going to have to decide whether to vote for Secretary Clinton for president. Now, Ms. Freifeld, I'm sorry that you and the other witnesses are being put in this awkward position today. The chairman invited you to a classified hearing, but he is now springing this on you. I will withhold most of my questions to the classified bit of this, but we have to talk about the marking of classified documents. I mean, it's being bandied about that documents can't be produced because they're highly classified. Well, to be classified, according to the manual, which follows Executive Order 13526, a document has to have something that identifies who originally classified it. It has to identify the agency and office of origin of the classification. It must identify the reason for the classification. It must identify the date of the classification. And they typically also have a banner, both across the top and the bottom, stating the level of classification: top secret, confidential, eyes only, whatever it is. Ambassador Kennedy testified that none of the emails provided to Congress had any of these indicators, and at our hearing we asked Ambassador Kennedy about 3 documents, 3 out of 30,000, that included a small c in parentheses, even though the documents didn't have any of these other indicators for classified documents. State Department spokesman John Kirby said the markings on those emails were an error and they were not, quote, necessary or appropriate at the time they were sent as an actual email, and Ambassador Kennedy agreed. We asked him about one of those emails dated August 2nd, 2012, and he confirmed that the C in parentheses in that email was a mistake. He also confirmed that every paragraph in that email was also marked sensitive but unclassified. And we asked Ambassador Kennedy whether the FBI consulted with the State Department about the classification status of this particular.
But this is just true. And obviously, when it deals with the secretary themselves, and particularly a secretary who, it turns out, had such huge financial dealings or financial dealings that concern her and her immediate family, don't you feel that maybe in responding to these requests, you ought to make sure that requests directly affecting the secretary should bubble to the top?
That is very hard to do, sir, when, per statute, I have to respond to every single FOIA request within 20 days. And so in order to avoid more lawsuits, we treat these things as first in and first out, and then we're at least able to assert to the courts that we are trying to move through this in a logical and measured progression.
Thank you. We're almost done. So I have just a few more questions. Mr. Ambassador Kennedy, when was the first time you knew that Secretary Clinton used a personal email address? Your microphone, please.
That came very, very late in the process, Mr. Chairman. I think it came to me probably in 2014.
The State Department Inspector General report says that in August of 2011, you discussed in an email with Cheryl Mills and others that Secretary's BlackBerry wasn't functioning, quote, possibly because her personal email server is down, end quote. That raised any red flags for you?
None whatsoever. I knew that Secretary Clinton had a personal BlackBerry. In fact, I had been asked. They had asked about personal BlackBerries, and I was told that she had a personal.
And you hear a lot of complaints, but we do appreciate it.
No, it's an honor, sir, to serve.
Mr. Chairman, I just wanted to close by pointing out that we've heard today about a broken and a flawed classification system. And I think if we don't do anything else, we can try to help with this system of classification because it is so serious and can create all kinds of problems. And I'm looking forward to working with you in an effort to try to address these issues as best we can. And with that, I want to thank you all.
I thank the ranking member. I do think we need to work collaboratively on not only the classification process, but also security clearances, because my goodness, you got millions of people with security clearances. And I still hearken back to what Senator Patrick Moynihan spearheaded some 20, 25 years ago. I can't remember the date, but when he basically issued a report, good bipartisan report that said, when everything's classified, nothing's classified. When everybody has a security clearance, nobody has a security clearance. So I do think that that's a long-term project that I would love this committee to engage in. I need to ask one last thing because it does impact the four of you that are sitting here. You have this trove. It's by the tens of thousands. You look at these federal records that are now suddenly dumped on your lap that didn't know were there. And then you also look at all the requests, congressional requests, subpoenas, FOIA requests, media requests, sometimes come in as FOIA, sometimes don't. How do you take those four sets of requests and cross-reference it with probably information from Secretary Clinton's federal records that should have been included? Is the idea that you're just going to throw them all up in the internet and everybody's going to have to go hunt and peck through the 55,000? Or are you going to go back to a subpoena and say, all right, that was actually not as responsive as it probably could have been. This FOIA request was incomplete because it should have included this particular email or her calendar, or whatever it might be. How do you take this set of the 55,000 or the pages, and now we hear it's tens of thousands more than that. How do you do that and cross-reference it with the thousands of requests that had been peppered into the State Department over the last, since 2009?
I think there are two ways to do that, Mr. Chairman. We could go back and go through every single previous FOIA request, and that I think would grind to a halt the requests and the efforts we're making now. I believe the right solution is what we are doing. We are putting all of the emails up on our searchable website. So if you ask about Xanadu and we told you we didn't have any records, You could go to this a special portion of our website, which has all the 53,000 Clinton records, and you could put in Xanadu, and it would find Xanadu for you.
You're not talking about the Record album that from back in the 70s, are you? I'm just teasing. Keep going. Yes.
Xanadu is my favorite country.
Okay.
Because it's not a country, and I can use it as an example without ever
I thought you were a big music fan of a particular artist from the 70s.
I can
but
shift
it's okay.
to
Keep going.
Shangri-La.
Yeah.
I think that that is the way for us to best be good stewards of the taxpayers' dollars, but also be most and quickest responders to the American people.
So why not just do that all the time? Forget about FOIA. Forget about subpoenas. We get stuff, well, let's put it on the internet. Good luck.
Because there is foreign government information, Privacy Act information, National Security Act information in that material. And
so you have no plans to go back and redo. What about subpoenas?
If someone, we respond to subpoenas. We work very, very
No,
closely.
but if you responded to a subpoena, say, and I don't have an exact one in case, and it came across in 2011, and you just got the record here in 2016, are you going to go back and look at that subpoena?
We would, for subpoenas, which we would consult with the Department of Justice about what we needed to do to be in compliance with the court.
I think I can
Or the Congress.
Okay, so that's what I'm saying. There's this universe of sort of 4 areas, 4 buckets, and I hope I'm not missing one, but you have FOIA requests, you have subpoenas, you have congressional inquiries, and you finally have media requests, which come in a variety of different formats. So I would appreciate, what is your game plan to deal with this? You didn't ask for this, but this is what the consequence of Hillary Clinton's convenience was, is you have to deal with it. So what are you going to do? How are you going to prioritize it? And what's the expectation if somebody has as a subpoena, if a company or an individual or an attorney or whatever it is, there's a subpoena out there, will you be going back and cross-referencing that
Let me
for
take,
each of those 4? And I'm not expecting you to do it off the cuff. I would just appreciate if the State Department would say, this is how we're going to deal with it. And if it's not those 4 buckets, tell me what it is, but at least off the top of my head, that's what it is. All I'm asking for here is a game plan to deal with that. I don't think it's good enough to just say, we're throwing everything up on the internet and everybody good luck.
that was in response, Mr.
And
Chairman,
the
to your
FOIAs
fo-
is
to your
so,
FOIA question.
yes.
We will review congressional document requests as we continually review them. As you know, Mr. Chairman, we've sent you 186,000 pages, and if it has to be 187,000 or 197,000, we'll work with you as we talked about when I met in your office. For subpoenas, we will talk with the Department of Justice to see what steps we may have to take and have our lawyers work on that. For the media, I leave the media to take care of themselves.
They'll be so glad to hear that. But if there was a media request,
the media request would be a FOIA request, and therefore we've made it very clear to the media.
At least for those 4, just what's a reasonable time that you're going to get the committee and a game plan on how you're going to deal with this?
It will, given that the legal question about subpoenas is a complex one, I think it'll have to be a couple of weeks because we have to.
End of the month, is that fair? Today's the 8th?
I can certainly try, but I have to talk to my legal advisor and I have to talk to the Department
We're going to start
of Justice.
waving the red flag saying, hey, you're not being responsive. I don't hear